We're joined today by Congressman Doug Collins, who has been confirmed by House Republicans as the ranking member of the House Judiciary Committee. Thank you so much for joining us, Congressman.
Well, thank you so much for having me.
In terms of in the next Congress and the copyright side of things, what are some issues specifically that you think need to be looked at?
We're going to continue, I think, with the Copyright Office itself. And I think as we look at the Copyright Office itself is going to be something as how that developed. And I think we saw that a little bit in music. We'll continue to work on those kind of issues. I think you still have small claims court. Those are kind of things for photographers, for authors and things, where they can not have to have the tremendous expense of going through the court system, but have this as an ability to claim back some of their property and content rights. And then there's something I think just in the general that we're going to have to do, and that's again a continuing education that no matter what the medium is, the content is the valuable part. It is the thoughts, the ideas, the hopes, the dreams, the ambitions. I've talked about this a lot. That it actually has intrinsic value. I don't think anybody in the world who's heard a love song and experienced love would not think that there was a value in that feeling or that emotion or that song. But finding that value is something that we need to always continue to educate and teach generations to come that this is a valuable part of our national economy.
Looking at tech and pharma industries, some businesses in those industries say that U.S. Court decisions recently have poorly defined what inventions can be patented, and they say that makes it harder for them to protect their innovation. What do you think? Do you think that there's a role for Congress to come in and perhaps redefine the definition of, or rework the definition of patent eligibility in federal law?
I think this is really one area that is a very tough discussion. You just named two players that probably in many ways have some similar opinions but very divergent opinions. When you get into Section 101, Section 112, the subject matter eligibility, patent quality, I think we've got to really start and look back at what is patent quality. How do we make sure that we have the best patents available that do what the framers of the Constitution, I believe, intended, and that is the specific idea in the specific context. What we've had, unfortunately, is there's been an expansion of that and a contraction, depending on how you want to look at it, that makes it difficult for people to say, do I have a verifiable claim that can withstand a challenge? And I think we've also got to make those challenges, in a sense, be very valid for those who need to protect their own work, but also make it very streamlined so that people can understand were's the point back. It all goes back to the patent, though. It all goes back to that original section. And I think those are the areas that we're really going to have to work on. I think Congress we're going to have to take it slowly, take input from all. I see this you had asked earlier about copyright and how that came out. Do we see that? And I go back to momentum here. This shows that it can be done. We just now have to do it with other players.
Got it. And shifting gears to trade and IP, China has recently batted U.S. accusations of IP theft. Do you think the current protections are enough to help U.S. businesses protect their IP abroad?
Not yet. They're getting there. China is a valuable trading partner with the United States. Their size and scope of their economy is not something that we can ignore, and because they are, have a lot of their own issues internally, but they also, in a world stage, are a very dominant player. So the question is how do we compete in a world that we've been competing in for many, many years, bringing our intellectual property to China without it being, having to be given away to gain access to markets and those issues that we're seeing in trade agreements. That's why trade agreements are so important, to define the playing field for intellectual property, not only on theft, counterfeit goods. That's another issue that we're going to have to, I think, address at some point, is the counterfeit goods issues that's coming in through some of the online and other retailers that are maybe not getting as scrutinized as they should, that are affecting legitimate businesses. So when you deal with trade, these are all big issues that have to be done. I believe we can do better. In my mind, those are sometimes overlooked because it is a difficulty, in trying to enforce them in other countries and with us. But those are the things that can actually make or break in the new economy, these trade deals.
There was some discussion in the last Congress about trade secrets perhaps being disclosed during litigation in foreign courts. So would we see some action on that perhaps?
That is something that's been discussed and how we will go about that. This is a good and a concerning thing. It's good that we have a worldwide trade. It's good that our doors are closer to each other, so to speak, in a worldwide community. The question is though, is protecting this across. I truly believe that America, although we've had some issues, and some say that we've sort of slipped in our IP protection, we still hold the standard for what content and protection ought to look like. The world looks to us. We have got to make sure that we're keeping that standard up so that the other parts of the world say, well, if the U.S. is lenient on this, then we'll be more lenient. And they've already started off at a lower standard to start with. So these are the kind of things I think, yes, that we're going to have to look at.